Hey, YouTube family and GN subs. Today we are going to talk about appeals from denial of marriage cases. Really important. You know, USCIS and the field offices immigration, they always try to deny you based on fraud. I've talked again and again about being able to appeal. I've had a real interesting situation in my office where clients hired me to file appeals. I saw two different instructions from two different field offices. Very confusing stuff. I want to make it clear, make it simple for you. Hey, those of you who are new to the channel, my name is Humberto R, attorney at law. I am here in Los Angeles, California, and I generally bring good news. I break down complicated subject matter such as subject matter today. Very complicated stuff you'll see, very confusing, but I'm going to make it very simple. And hey, give me a thumbs up, like and subscribe, and we answer all of your questions that are posed in the comments. So leave me a question in the comments and I will certainly answer you. You can get me at hrg@graylaw.com. No other phone number, no other website, no other nothing. There's a lot of fraud that's going on around there. So hey, let's get to this I-130 appeal content. Very good stuff. You are going to be very pleased at the information that you're going to get today. All right, so the first thing that you need to know is jurisdiction. Jurisdiction means where do I appeal? You appeal I-130 denials to the Board of Immigration Appeals. This is the higher entity that looks at these cases, these marriage cases. We've gotten a lot of great law out of the BIA. So that's where we're going. We're going to set this up for you, okay? All right, this is crazy. Look at these two denials that I just recently got to appeal for clients, all right? So one is from San Bernardino, one is from Santa Ana. Santa Ana actually gives you the incorrect information. Look on the final page of this form. It says you need to appeal with an I-290B form. That is not correct, folks. That is so wrong. All right. So you got to be very careful when you're looking at these. I'll tell you what to do and how to do this. So don't worry. I'm just giving you a comparison. Look at the one from San Bernardino. Yes, they tell you how to appeal correctly with an EOIR-29 and an EOIR-27. They do give you the correct location, etc. This is California, folks. San Bernardino did it correctly. Santa Ana gave incorrect information. All right, so we've told you this before. This is important to know. The I-130 is the petitioner, the U.S. citizen or permanent resident. It's their petition. You have to understand this, okay? It's their petition. It's not your petition, all right? So why is this so important? Let's take a look at the forms. Okay, this is confusing as well, but again, this is why I'm doing this video, because you need to be clear on this stuff and you need to do it correctly or you're going to lose your chance on appeal. Case over with. Fraud is always going to be there. So you got to pay attention. This is probably one of the most important substantive videos that I've done. All right, let's pull up the form EOIR-29 and take a peek at it. This is the form that is used for the appeal. Now, again, petitioner's application, right? But look at the information that they're requesting. They're requesting information from the beneficiary. You see that? You do provide the information from the beneficiary, but the petitioner signs this form, not the beneficiary. So it could be very confusing, right? And you don't have to take my word. You look at the instructions on the back of this form. It tells you for an I-130 marriage petition, petitioner is going to sign the form. Beneficiary needs to provide the information, okay? Doesn't make sense to me either, but it's how it's done. All right, let's take a look at the EOIR-27. So this is a form for the attorney to represent the petitioner. Information that goes on this is petitioner's information, and then me as the attorney, I sign it and we send it off. All right, we're going to go to the government website. This is very interesting too, right? So generally, I say you want to follow the instructions that are on the government website, okay? It's going to be most accurate. It's probably going to be up to date. That's what I would do. So let's go. I put a link in the description box below for the EOIR-29 and instructions on where to file, okay? Again, this is very interesting because there's conflicting information on the website. It says to file the appeal at the location that is indicated on the denial. All right, well, let me tell you exactly where to file. Always, this is in all cases, you file at the office that made the decision. Not at the BIA. You're going to see something with the AAO Administrative Appeals Office, etc. You file it at the location that made the last decision. This is generally the field office, okay? We used to call it the district office. It's the last office that made the decision. That's where you file. All right, the good news also is that this EOIR-29, the fee is $110 versus the I-290B, that's $700. So, if you file the wrong form, they may, take the case, sit on it, cash the check, and you lose that money. So you can save a lot of money here, folks. $110, that's the current fee. Again, that's indicated on the USCIS .gov website, which is good stuff. So what do you file? All right, so you file the EOIR-29, the EOIR-27, a brief. Usually you want to write down the reasons for your appeal, why immigration is incorrect, okay? The brief and then the filing fee of $110, okay? That's what you file. All right, so when do you file the I-290B, which is a separate form? There's a different situation when you're filing the I-290B. Generally, I file the I-290B when immigration has made a mistake. It's called motion to reopen on service error. This means they've made an error. We used to be able to file these without a fee. Unfortunately, they're not taking them at the field offices unless there's a check with it. So if immigration made a clear mistake, I'll give you an example. Let's say that you filed your RFE or your NOID on time and you have evidence of that. They nevertheless deny the case and say that they didn't receive it on time. Okay, so that's a clear error. This is when you'll file the I-290B. Hey, YouTube family and GN subs, thank you so much for watching GrayLaw TV. Click below, like, and subscribe. Give me a thumbs up, and we'll see you next time.